February 23rd, 2015. We're kicking it off for the trial kickoff. Coalition members here from across the country. So Dana, you're out in force. We got Mark Emery, DML, we got everybody in the house, all national activists out here doing their thing. What's your take on this Allard case, and what exactly does this mean for Canada?
Well, we all know this is a very important case. We support patients' rights to grow their own cannabis, and really all adult Canadians' right to grow their own cannabis. And I think that this case is important for the patients that need it, but it could also set the template for what legalization will look like for everybody else as well.
Our secretary of the Cannabis Rights Coaltion has been refused entry to be able to go upstairs and actually see the courthouse and the court proceedings. That's outrageous. Jen?
I was absolutely irate. It's the same security guard that's let me into 2 court dates with my medicine. And he refused me and told me that this medicine is absolutely not allowed in the courtroom. And I told him he's let me in with it twice. He says it's not allowed, and he actually told me to go and put my medicine or give my medicine and leave it somewhere, not in my care, which I'm not allowed with my license to be just leaving my medicine laying around. It's absolutely wrong.
Kirk, well, I didn't have a chance to get up in the courtroom. We've been out here just raising a lot of awareness. Maybe you can give us a fill-in on where you feel, how you felt the kickoff of the trial went and the opening arguments from the Crown.
Yeah, I think we started strong. I mean, John Conroy laid out our position, which is essentially that this case is about people's rights. It's not about the commercial system. It's not about whether that commercial system is effective or a failure or not a failure. There's a lot of criticism of it. It's not about whether the government can regulate commercial entities that are making health claims and selling products for profit. This case is about whether or not it's illegal to have home gardens, whether or not it's constitutional to visit all the harms of the criminal justice system on people that want to produce medicine safely and effectively for themselves, as they have been for years and years under the old scheme.
And Saturday night's kickoff, just so everybody knows, $20,000. That's the largest fundraiser we've ever done. $20,000. $17,000 was the previous largest. So $20,000 Saturday night.
I think the testimony from Mr. Davey this morning was really a highlight of exactly what the problem is. This is a gentleman who's had a brain injury, serious brain injury, changed his life entirely. And as a result, he gets put on a whole bunch of prescription drugs that make him have no quality of life. He finds medical marijuana to be effective. He regains the quality of life that he had, not pre-accident, but you know, he's way better off than he was on the pharmaceutical substances. And he wants to know what's going into his body from the seed to the harvest. He wants to know what the inputs into the process are, and he can do that in his home garden. He can't do that if he's forced to go to a commercial supplier. He also can afford it. I mean, bottom line is, Crown seems to be suggesting that, well, because he's got you know, about $2,000 difference between his monthly income on disability and his annuity from his accident, and what he spends every month in his living expenses, well then he's perfectly fine. He should spend all that money on marijuana and buy it from a commercial entity and sort of line their pockets with profit. But doesn't the man have the right to have some savings? Doesn't he have the right to have a little bit set aside to take a trip or to visit family or to fix his truck if it breaks down? I mean, should he really be forced into spending every dime he has every month to buy medicine when he can produce it for himself at a fraction of the cost? And oh, by the way, even if he spends every dime, he can't get enough. So you know, I thought the evidence this morning went in quite well, and I'm looking forward to the rest of the trial.
I think patients should have all those rights. They should be able to grow their own, should be able to buy it at a local dispensary, should be able to get it by mail order from one of these companies if that's what they want. But you know, Health Canada are the ones whose regulatory failures have created all this stuff and opened all these things up for us. If they want to get rid of dispensaries, it's easy. Offer way cheaper, higher quality, better product than we can offer. I would happily shut down if that was the case, but we're a long way from getting to that point. But it's Health Canada and the government's intransigence on this that has resulted in all this chaos and all this stuff. It's not us. We're not the problem. We're just trying to access medical cannabis, grow our own, and be good citizens. But it's the government's terrible programs they put into place that have caused all this confusion and chaos.
I also find it interesting that just in closing that they introduced this as fire, mold, and organized crime as being the reason, public safety, and now it seems to be more about the bottom dollar.
Well, that's right, and the difficulty is, if you look at the injunction materials, they don't have a lot of evidence supporting fire risks or mold risks or organized crime risks. In fact, they can't seem to point to any cases where those risks have materialized in the real world. So I think you're right. There's a bit of a shifting focus here because they realize their arguments on those points simply fall short of what the facts actually support. So it'll be interesting to see as we go forward, what is the Crown's justification for trampling on people's Section 7 rights, causing them harm to their health and causing them harm to their safety.